Good afternoon, everyone. I'm here along with President Cassidy Caron and Ministers Hajdu and Anandasangaree to comment on the Supreme Court ruling in relation to Bill C-92. I want to first start by saying that this constitutional challenge that was brought forward by the province of Quebec has delayed the implementation of this act by years in some cases, has created an atmosphere of confusion and sometimes concern when it comes to provinces and territories and federal departments working with us to implement our existing rights, especially those in relation to the care of our children. And so this is a very positive day in regards to the Supreme Court ruling. The further galvanization of the United Nations Declaration on the Rights of Indigenous Peoples here in this country, as interpreted by the Supreme Court, and also for Canada at the federal level to enter into constructive arrangements with First Nations, Inuit and Métis to develop these types of pieces of legislation that allow for us to express self-determination in the multitude of ways that it is within our right to do. In regards to Inuit and in regards to Inuit children in care, this has been an ongoing, just tragic reality that there are too many Inuit in care across this country. And in some jurisdictions, they're taken into care based on poverty or based on socioeconomic determinants of care that are often not to be borne at all by the parents or the communities, but by the systemic lack of equity across this country for socioeconomic conditions within our communities. Bill C-92 pushes back against those realities, pushes back against colonial attitudes towards taking children away from their families, and pushes the Canadian state to recognize representatives of Indigenous peoples, Inuit rights holding institutions and organizations, along with First Nations and Métis, to take care of our children and to implement self-determination in this field. This has been a long road to get to this day. We were very pleased with the support from the government along the way, especially Ministers Philpott, Ministers O'Regan, Minister Miller, Minister Hajdu, who have all worked with us as Ministers of Indigenous Services and Ministers of Crown-Indigenous Relations to get to this point today. I look forward to implementing this act with Ministers Anandasangaree, Minister Hajdu, and provinces and territories across this country. And we will use this Supreme Court ruling to ensure that we do this in the most expedient way possible, that we have the resources and the space to be able to make constructive arrangements, and that we will not be impeded by the demands of provinces and territories who would imagine that we do not have this right or are trying to put roadblocks in the way of implementing this right that ultimately come at the expense of those who need this act the most, which is the children in care across this country and those who are in the social services systems who need their community and their loved ones to be with them by their side, to make decisions in their best interests, and to give them a chance to have a positive future full of pride within where they come from, our language, within our communities, and also within our governing structures. Nakumik.
Tansei Kiwao, good afternoon, everyone. I'm proud to be standing here today to be able to provide some remarks on the decision that was released this morning. The Métis National Council is extremely pleased with the Supreme Court's decision, the unanimous decision to uphold this forward-looking, reconciliation-based innovative piece of legislation that has the real ability to create some incredible changes that are so necessary within our communities for our children and for the Métis Nation as a whole. The Act, Bill C-92, provides the legislative framework for our Métis governments to now fully exercise their jurisdiction in relation to child and family services, something that we've always known was an inherent right for the Métis Nation. And this decision also confirms that, the federal government is on the right track in advancing legislation that affirms our rights that are protected by Section 35, rather than opposing them and continuing to deny that we have Section 35 rights. Currently, for the Métis Nation, we have Bill C-53, which is an act to recognize certain Métis governments, and it's premised in the same affirmation of rights. So I really want to applaud the current federal government in advancing the act with the Métis Nation and other Indigenous peoples. This act was collaborative, it was done in co-development, and I think the decision that was made today really shows that this type of collaboration and this type of co-development with Indigenous peoples is the way forward. This is how we implement the United Nations Declaration on the Rights of Indigenous Peoples. This is how we move forward in a really good way. C-92 is a piece of legislation that is it is legislative reconciliation. It was stated that in the decision today, and I truly do believe that it has the ability to remedy past harms of colonization. It has the ability to remedy current harms of colonization, of taking our children away from our families and putting them in the care of people who don't know how to care for our people. So the Métis Nation looks forward to continuing to enter into constructive agreements with the federal government and to continue down this pathway in a really good way. So thank you so much.
Hello, bonjour, and I want to first off acknowledge that we are gathered on the traditional unceded territory of the Algonquin and Anishinaabe people, and I want to thank Minister Hajdu and all the ministers who have been working on C-92 for many years, and I want to thank President Caron and President Obed, as well as National Chief Woodhouse for their hard work and advocacy. Today marks a pivotal moment for Canada and Indigenous peoples, with the Supreme Court of Canada upholding the Act's affirmation of Indigenous jurisdiction over child and family services. Aujourd'hui marque un tournant pour le Canada sur le chemin de la réconciliation. In my conversations with First Nations, Métis, and Inuit families, they express a desire for a future where they make decisions on how best to protect their own kids. And indeed, yesterday, when we had the second IFPT on missing and murdered Indigenous women and girls, we heard from many survivors, as well as those who work on the ground, for the need for us to move faster in implementing C-92. I believe that this decision really does open the way for Canada and those who want to draw down this jurisdiction to move forward in order to ensure that children are kept in their homes and in their communities, and ultimately Indigenous people have their right of self-determination over their children. Today's ruling is a landmark achievement and an example of Canada is meeting its commitments to both implementing the United Nations Declaration on the Rights of Indigenous People, as well as responding to the 94 calls to action of the Truth and Reconciliation Commission report. This is a historic step forward in advancing reconciliation. L'arrêt d'aujourd'hui est une étape importante dans l'affirmation de cette vérité. Il marque une avancée significative vers l'autonomie. Thank you, and I now welcome Minister Hajdu.
Well, thank you, everybody. C'est un jour historique pour les enfants et leurs familles, pour Canada, tous les Canadiens. It's really affirming to hear partners speak about how important and emotional this decision is today. Forever, since time immemorial, First Nations, Métis, and Inuit people have had the right to take care of their own children and families, and that right was ripped away by Canada, by provinces, and by territories. in chapters that many of us know very well, and in some cases many of us Canadians are only coming to realize. The decimation of a family structure is a tool of colonialism around the world, separating parents and their children from culture, from language, from family, indeed from love and from care, is a tool that colonizers have used to diminish and oppress people all around the world, and it's been no different in Canada. And the result is well documented in history books and indeed is ongoing in many communities where people have the ongoing trauma and the grief and the angst of either not knowing their parents, not being connected to their families and communities, not being able to connect with their own language and culture. And on the flip side, the many, I would say, deeply moving stories I've heard from families who have lost their children, lost the ability to connect with their children, lost the ability to fulfill, in my mind, one of the greatest honors of being a parent, which is to care for and nurture and raise our children and see them grow into adults. And so this decision by the Supreme Court to uphold that inherent right, to recognize the legitimacy of federal law, to bolster that right and to place that right in Canadian law, I think is going to have tremendous impact across the country. I've been a witness at the signing of many coordination agreements, and I can't think of a more moving event than when a community has completed their law, has completed the coordination agreement with the province and the federal government, and is resuming the care and control of their own child and family services and their own rights to take care of their children. They are very emotional moments where families of all different stripes gather together in celebration and in mourning for what has been lost over, I would say, generations of people harmed in this way. And so I'm very profoundly struck by the court in their decision noting that this is legislative reconciliation, that we have many ways on the path of reconciliation to make good for the harms that have happened, or try in many ways to repair the harms that have happened, but also to move forward in a spirit that in our best of interpretations, our ancestors agreed to in many different treaties and agreements along the way. So today is truly a historic day, and I am very grateful for the colleagues that came before me. President Obed mentioned then Minister Jane Philpott, Minister Seamus O'Regan, Minister Mark Miller, who paved the way for this legislation to become law. But I am also extremely grateful for the Indigenous partners who sat with us and made sure that this law reflected what they wanted to see in it. And really, it was a very important step on the pathway that I think Canada is on in living up to the spirit of the UN Declaration of the Rights of Indigenous People to have law co-developed, co-created with Indigenous peoples to make sure that law in this country never harms people like this again. Thank you.
What do you say to the province of Quebec?
What I say is this is a clarion call for all provinces and territories to be partners in this reconciliation, that it is now the law, actually, that that work has to continue. But what I would also say, c'est très important pour la famille et les enfants de la province de Québec pour cette réconciliation. C'est un enjeu de vie ou mort. C'est un très important enjeu. We're not talking about a nice to have. We're talking about actually the survival of families. Minister Anandasangaree is right. There is a huge connection between things like missing and murdered Indigenous women and the disruption of family, the disruption of culture, the disruption of love in many cases. And so this is an issue that I think we should all be seized by as Canadians. And
why do you think they fought C-92?
I can't actually give you hypothetical
No, they
reasoning.
thought it was a matter of jurisdiction, did they not? They thought it was an overreach. So what
Well, the court has determined that the federal law is in fact legitimate and that it does establish inherent rights for Indigenous people to control their own child and family services, and I am very thrilled with the ruling.
Can we introduce similar legislation? Ghislain Picard this morning said that for him, this paves the way for more autonomy in other areas, like healthcare, for instance. Do you see this decision the same way? Do you think it paves the way for more autonomy, and could we see things concretely soon?
Je suis d'accord avec chef Picard. Je pense cette loi est très importante pour l'autodétermination pour tous les autochtones dans le pays et pour beaucoup de sujets qui touchaient la vie des peuples.
Donc, vous déposez un projet de loi sur la santé?
Pardon?
Allez-vous déposer un projet de loi pour
Oui,
accorder des
oui,
pouvoirs?
c'est pour
You're going to introduce legislation
Well,
to...
yes, yes, not tomorrow, but yes, it does actually inform things like health legislation that asserts self-determination and health provision. It is, I think, going to really help with the debate that we'll be having on the care and control of water sources for First Nations people that, as you know, is a component of the newly tabled and just gone through second reading Bill C-61, an act to protect First Nations access to fresh water. These are the kinds of deliberations that I think First Nations, Inuit Métis people will be having, and that the Government of Canada will also be having.
Do you believe that Indigenous peoples should be recognized as a third order of government? Why do it in this piecemeal fashion? Why not extend that broader recognition? And I'd actually like to hear the Indigenous leaders on that as well.
Well, why don't we start with the Indigenous leaders?
Well, first, in some of the questions, I think it's important to recognize the challenges that Canada has had as a country, and also politically from provinces, territories, and the federal government in recognizing the United Nations Declaration on the Rights of Indigenous Peoples for what it actually is. It's a compilation of existing human rights that Indigenous peoples is Indigenous people specific in its scope, but it is universal in the fact that these are a compilation of existing human rights. These are common law human rights enjoyed by people around the world. Canada, for much of the conversation around UNDRIP, has purposefully misrepresented what it is. And you can hear anyone talk about this in a sense of principles or aspirations in relation, in really what you're looking at now is the Supreme Court recognizing what we all have been trying to say for now 15 to 20 years, that these are rights and obligations. And it is piecemeal, Brett, in response to your question, but incremental change is better than no change at all in regression into the scenarios that Indigenous peoples have found ourselves for much of Canada's history.
Yeah. Are there other fields in which you would like more autonomy specifically? Like, I know Ghislain Picard mentioned healthcare. Like, is that a priority, or what are the key priorities in terms of more autonomy, self-determination?
Well, I think we can look to the UNDRIP Act and the associated action plan. There are distinctions-based action plans that were released last June. And in each one of those sections, there are specific tasks that we hope to engage with Canada on for the implementation of UNDRIP. One of the key considerations for the universality of the implementation of our existing rights is a human rights tribunal, a specific mechanism to ensure recourse and remedy for Indigenous people's rights when there is a violation of rights or there is not an upholding of rights. It is a gap in the human rights regime in this country, and it is something that ITK and now MNC have both been pushing for now up to 7 years.
I just have a question for Mr. I must apologize. This is for my Quebec colleagues. It's on a separate matter. It's who's behind me here. It goes in English. Manawan is asking for an increase in funding to make up budget shortages in healthcare. Currently, Manawan is struggling to find lodging for Joliet healthcare patients. Will you be increasing funding to this community?
Well, thank you for the question. I don't have a precise answer, but I will get back to you on the precise answer. We'll always work with communities on shortfalls that they have and making sure that people get the services they need.
On the question of funding and implementation, the National Chief said earlier today that in order for this act to really have true meaning and substance, it needs to have the funding to back it up. I'm just wondering what next steps the government has in looking at implementation when it comes to funding nations in order to really be able to put this act into action and being able to actually care for children in their communities.
And thank you for that question, and I think it's a very important flag from the National Chief. And I would say that the coordination agreements that we've concluded, a big part of those negotiations are on the appropriate level of funds and the stability of the funds. Usually they're 10-year agreements so that communities have the long runway to understand what they will have and how they will use the money to protect families. There's a huge prevention piece to this work, by the way, to make sure that families have what they need so they can stay together. There is obviously many times human resource implications, and so each community negotiates as part of their coordination agreement the appropriate level of funding, and those are collaborative conversations with the federal government so that the federal government really understands what needs to be in place for that certainty that communities and regions have said that needs to be in place for this to truly work.
Will the government be putting any more money into child welfare in the budget?
So these coordination agreements, as I said, are done individually because, of course, it's hard to estimate what one particular community or one region will need and apply that to other communities. There are distinctions for different coordination agreements. For example, remoteness may be an aspect of the funding that could change the funding formula for that particular community. But this government, as you know, has a significant commitment to reforming child welfare, and in fact, those negotiations are underway with $23 billion of money that has been set aside to complete that work.
From my understanding, only 7 Indigenous governing bodies have taken advantage and decided to, have their own child welfare system. Why is that, and is there any way that the government can help improve uptake?
Well, thank you for that question. I think, first of all, this is a huge undertaking by a community, and depending on the community's priorities, they may be working on a number of different issues. So I can't speak to the motivation, of all communities across the country, but I can say that we have heard, especially while this challenge was going on in the Supreme Court, concern that people would do all that work and that somehow the law would be declared illegitimate or that the law would not actually cover First Nations autonomy and inherent rights. And so I'm anticipating that we will see a number of communities come forward who want to begin the process. The process can take anywhere between 18 to 24 months for the community to write their own custom law or code, in many cases set up their own First Nations family and children services, which might be named differently or conceptualized differently. And the federal government works with communities at the speed that they wish to work.
The pieces of legislation that, for instance, we're talking about healthcare, what's the timeline on this? Like, when could this come?
Well, listen, again, I am hopeful that we'll be able to table legislation in the next 6 to 8 months, but it's very hard to say. There are a lot of factors that go into this. I mean, this is work that is distinctions-based. In the case of C-92, it is an overarching umbrella that provides that legislative inherent right to child and family services for all of the distinctions, but not all parties are in the same place on what self-determined health legislation should look like. So those conversations continue.
Saying that child welfare.
Sorry, I'll just go to this.
You're saying that child welfare is very important to your government. You're happy about this decision. But on the other side of child welfare is healthcare. Cindy Blackstock has a motion at the Human Rights Tribunal saying that your department doesn't even answer the phone for Jordan's principle. How do you square up those two sides of what your government is doing?
Well, Jordan's principal requests have gone up by 150% just in the last year, which is a sign of the uptake of Jordan's principle. I'm very proud of so many children across the country getting access to Jordan's Principle care, whether it be for immediate health, urgent health needs or longer-term needs, including things that help children thrive, like access to tutoring or specific products that they need to learn, to grow, or to be healthy. We're going to continue to make sure that as the demand grows, that the department has what it needs to respond quickly to those requests. And I would say, look, these things are all complementary, absolutely. First Nations that have coordination agreements still have access to Jordan's Principle services, and in many cases have the capacity to be able to tap into those services very quickly. And so these are all complementary pieces, all with the same goal, to make sure that children reach their full potential.
It is a 150% increase in uptake. Isn't that your department's job to figure out how to deal with that?
And that is exactly what they're doing.
Can I, if I may, sorry, I don't really like the structure of this and barking out questions. Could I ask you a question, President Obed, please? Could you come to the mic? Thank you. Off the top, you mentioned the delay, the result of Quebec pushing back. What is the impact on Inuit children of that pushback and that delay?
Well, we've co-developed this piece of legislation with the federal government, with Métis, and with First Nations. We're very proud of the end result. And this is, I think, the key piece of legislation over this government's reconciliation agenda of the last 8 years that we had the highest hopes for from a practical perspective. The Inuit Regional Corporation has created a piece of legislation and has started to take down these services. Makivik Corporation in Nunavik has informed the government that it is wanting to enter into an agreement, and we know that Nunatsiavut in Northern Labrador is on the course, that same course. The concerns that we have around the Supreme Court case and the court case that is brought forward by Quebec is that the entirety of government has been waiting for this decision, from Indigenous Services Canada, Justice Canada, Crown-Indigenous relations, and then into our self-governing and rights-holding institutions, the consideration about where to spend time, where to spend resources, how quickly we can be able to work collaboratively with governments in these jurisdictions. In listening to the interventions by provinces and territories within these Supreme Court proceedings, we often see in very black and white what jurisdictions actually think about our rights. And that also then creates a concern about how to then engage with that very jurisdiction about coordination agreements and about faithfully implementing our existing rights. We still live in a country where our rights are contested, and especially by jurisdictions who would imagine that their control is always superior to the rights of Indigenous peoples. And we at the federal level are pushing back against that with this government, and I'm very proud of this particular piece of legislation in that regard. But I wouldn't undermine at all the sense of risk that has been introduced by this Supreme Court case up until today. If this Supreme Court ruling had gone very differently, we would be looking at perhaps even starting from scratch on how to care for our children and how to implement our existing rights. So I can't underestimate enough how difficult it has been to have to put our hands in the courts, and especially in this particular ruling. And we're very pleased from the Supreme Court decision. But it shouldn't be this hard, especially since we have had so much goodwill in relation to recognizing UNDRIP, recognizing Indigenous peoples' rights to self-determination, the Constitution Act of 1982 with Section 35. We continue to piecemeal go through our way to claw and really fight for the implementation of our existing rights. And as much as politicians have said that that isn't going to be the case moving forward, that is our experience, and that is our experience within this particular instance.
Can I do one more question to Minister Anandasangaree? I want to reiterate my... Sure. Yeah, I just saw you nodding as Mr. Obed was speaking.
Do you have anything to say about what Quebec's decision to take this all the way to the Supreme Court says about maybe the work that still needs to be done with regards to reconciliation in that province, maybe other places?
Yeah, I mean, there are no historic Métis communities in Quebec, so I can't speak specifically to Quebec, but, you know, it was over 40 years ago that our rights were recognized and enshrined in the Constitution, Section 35. And for the last 40 years, we've been fighting in the courts to determine what those rights are and how we will be implementing those rights. And so, you know, for us to take a huge step forward with this piece of legislation, C-92, a co-developed piece of legislation that charts a pathway forward for us to implement one of our inherent rights, and for that to be called into question by one of the provinces, you know, it's frustrating, but not surprising. I hope that, you know, this Supreme Court ruling does pave the way for future pieces of legislation that are co-developed, that we can continue down this pathway of legislative reconciliation instead of having to go to the courts to fight for what our inherent rights are and how we will be implementing these rights. And so, again, I commend this government for taking these steps forward in such a good way and working with us. And hopefully, you know, we don't have to continue spending so much time and resources and energy and money fighting in the courts to move forward on what we know has always been our rights.
We're going to take one last question.
Can I ask one question to Minister Anandasangaree? I want to reiterate my original question more directly to you. Do you believe Indigenous governments more generally should be recognized as a third order of government in Canada?
I think there are a number of ways we're moving forward on recognition of governance structures. We have had a number of modern treaties, some 26 over the years. One of the dangers when we do it in a carte blanche way, and many have critiqued that it essentially sometimes becomes very similar to municipal government, and that's not what the objective is. It is important that we have continuous engagements and negotiations to ensure that when we have self-government agreements, they're meaningful and they draw on rights that the nations and the communities want to do. So I believe this is a process that does require both the Indigenous peoples and governments. In some cases, it's trilateral. In many cases, it involves provinces working together. If you look at yesterday, we introduced legislation to recognize the Haida Nation, the Council of the Haida Council, as the government of the Haida people. I think that's the type of way that we need to move forward. I do recognize the frustration as sometimes it does take a longer period of time, but when we have trilateral agreements involving the provinces or on issues where there may have been a longer delay, we do want to get to the right place, and there are a number of very advanced negotiations that are at play that we believe will come to a conclusion very soon. So we do look forward to ensuring that self-government agreements and governments are established through the mechanisms that we have, and it is not a very simple, it's a bit more simplistic to say we're just going to establish as a third order of government, because it would be in some ways not the prudent thing to do and have communities that are maybe struggling just right now with basic needs to be able to step in to be governments. But we do want to get there, and that's the work that we're undertaking. Thank you.
So much, everyone.
I'm actually, if I could follow up, Brett, on this. And for Inuit, it's a very interesting question. And unequivocally, Inuit rights-holding institutions have orders of government within this country. I think of where I'm from in Nunavut. It's a self-government with a constitution, with legislative status. It works with its jurisdiction, Newfoundland and Labrador, and the federal government. And so perhaps not a third order of government, but an order of government that has legitimacy. And the challenge, I think, within this country is to make sense of Indigenous governance, First Nations, Inuit, and Métis, and how it fits within Canada's overarching governance structure. We always think about provinces and territories in the federal government as understandable, as just natural in their orders and how they serve people. Same with municipalities. Indigenous governance often has been a mystery, and often I don't think anyone's really cared to actually understand it. A lot of my job in the last 8 years is to try to educate this government and Canadians about the existing governance models for Canadian Inuit and the respect for those models in the work that we do at the national level and the work that we do in provinces and territories. So taking on, again, the incremental approach, I think there's a lot that Canada excuses itself from in relation to ignorance on Indigenous governance. And the first step is for governments to recognize and truly uphold the governance that Indigenous peoples have put forward as our self-determination right.
Minister, if I could just get one last question. I just want to quickly. Thank you.